All right, so I want to talk about legal writing. I'm not talking about the kind of legal writing that would involve, say, a article in a law review. This is more practical tips if you're a litigator and you're filing things with the court, or you're preparing memos for your clients, or you're involved in contract negotiations and you're putting together proposals. There are some things you need to keep in mind when drafting your documents. The first thing I would tell you is think first. Before you get on the computer, before you pick up a piece of paper, before you pick up the pen, just sit down and ask yourself some questions. Do you understand the issues? What is this about? That's really important before you start diving into drafting, because in a lot of manners, the thought process is the writing, right? The writing can be just the putting it onto paper, but your thoughts are the genesis of what you're going to be presenting. So before you start anything, start asking yourself questions. What is this about? What are the issues? Do I understand the issues? Do I understand the facts? Number two, and I can't emphasize this enough, be brief. We in the legal profession are extremely busy, and brevity is what you're shooting for here. You want to make your point as quickly as possible and stop. Nobody wants to read a 50-page memorandum of law on a very simple motion. You know, the history of the statute. That's something that you would do if you were writing an article for, you know, an academic pursuit. That kind of thing, if that's produced, and I've seen those, the first thing you think about when you see it is, I don't want to read this thing. I don't have time to read this. 50 pages with footnotes, and you know, it's counterproductive. What are you trying to do? You're trying to communicate something, and you want to do that as briefly as possible. Related to that, I would say after you've gone through your first draft, go back and cut every unnecessary sentence. You're going to find as you write, you're going to kind of be repeating yourself because you have a point you want to drive home, and it's really important. And when you go back and read the draft, you'll see that you've repeated yourself. Just start cutting stuff out, and then when that's done, do that again. You're trying to narrow this down so that somebody picks this thing up, boom, there's the issue, there's your contention, there's the law that you're relying on, done. That's what's going to get read. You want to proofread your draft one more time than you think you have to proofread it, right? So maybe you've proofread it a couple, 3 times. You think, okay, that's good. That's fine, but I would do it one more time. You're going to be surprised what you find as you continue to read it. Now, when I proofread, I know some lawyers do this. I find this very effective. Maybe you will, maybe you won't. But when you're proofreading something, if you read it aloud, a lot of times things that you would miss by just reading it come out. So in fact, I'm proofreading as I'm drafting. So I'm drafting, I get to the end of a paragraph. I go back up and I read that paragraph. You'll be surprised at how many things will pop out at you. Now, in terms of proofreading, and I guess this is stylistic, but I am a real stickler for typos, grammar, etc., citations. When I see something produced by another lawyer, it's got typos in it, the grammar is wrong, the citations are wrong, it looks sloppy, the impression I get is this is not a very good lawyer. And you might be a very good lawyer, but you have very bad writing skills. And if you're a judge and you get this, it's going to affect how you rule on the case. It may not be dispositive, but it could have an effect. You will be surprised in your practice the junk that you get from some lawyers. You look at that, you think, how would you possibly let this go out of your office? This is a mess. This is signaling, hey, look at me. This is a mess. This is what my law practice has produced. This is my work product. And number 4, avoid verbosity. We've talked about that already. You know, there's something you can say, maybe you can say it in a little shorter way. You know, so try to find those ways to tighten things up. The other thing I would tell you and this is a practice that I can recommend to you, is when you get into a project, whether it's an appeal or a brief, and it's really involved, and you've spent a lot of time on it, you're in, right? And you've read it 4, 5, 6 times, and you've proofread it. Here's what I do. If you have the time to do it, I put it away. I go on to other things. I forget about the case, and I diary it for, say, 3 days later. You go back to it with really a fresh pair of eyes, and you'll start to see things that you didn't see before because you keep reading it over again. You're just going to gloss over some mistakes. So put it down and come back to it. Number 6, this is personal, but I think you need to master the approved citation form. I see stuff all the time, the citations are not right. Now, maybe this is a technical thing and I'm just being too picky, I don't know. I just think it looks professional when you're properly citing a case, a statute, legislative history, whatever it might be. Is it really that hard to get a blue book and just make sure that you're citing it correctly? I don't know, I think it makes it more professional. The other thing I would tell you is you want to summarize your conclusions right up front. A lot of times what will happen is you get this detailed fact pattern set up right in the beginning. And remember, you're writing this thing and you've been working on it. You're like step 2, step 3, step 4, step 5. A judge is back at step 1. He or she doesn't know what this is about. All of a sudden you're getting this 10-page statement of the facts, and they're thinking, what's the issue here? What are we trying to decide? I like to put that summary up front. Here, in a very brief way, this is what the issue is, this is what our position is, this is our conclusion, in a summary section. And then you can go on and start to intermingle the facts with the issues and then present the law. But as they're reading that, they already have in their mind, oh yeah, that's the issue I'm looking for as I read through this. Oh yeah, that's the conclusion of this particular party. I think it's much more effective. So these are things that you should keep in mind as you're drafting documents in your legal career.